So you're in your home minding your own business when local cops bust down your door without a warrant, based on nothing more than a hunch. As you round the corner, they think they see a gun, open fire, and shoot you. Now imagine the Trump DOJ defending that as okay, but it gets worse. As we reported previously, the DOJ is also gagging GOA from reporting on ATF's warrantless spying on gun owners. Meanwhile, DOJ is fighting in court to keep Biden-era zero-tolerance gun control alive. In the past couple of weeks, we've seen the DOJ go south on the First Amendment, Second Amendment, and the Fourth Amendment. And so we're wondering, is there any part of the Bill of Rights that the DOJ still likes? I'm Phil, and you're watching Law and Ammo. But don't get me wrong, because President Trump has been a powerhouse on many fronts, and not just on the Second Amendment, on a whole host of issues. But he has been pushing pro-2A policies. But the Department of Justice and ATF are causing some serious heartburn right now. And recently, they've taken actions that trample on the First, Second, and Fourth Amendments. And so today, we're diving into the details, starting with a shocking case where the DOJ is backing a warrantless home invasion that ended in a gun owner getting shot by the police. We'll tie it back to the broader headaches GOA's facing with the DOJ on Second Amendment issues and top it off with DOJ's attempt to gag our free speech. And all of this isn't just due to a bureaucracy that can't be managed. It's the exact opposite kind of behavior that we've been getting from President Trump since he was inaugurated. But there is something you can do. Your voice can fix this. And let's break it down. First, there's the Fourth Amendment case. This is in regards to William Case v. Montana. And this stems from a tragic incident where Montana cops conducted a so-called welfare check on a man named William Trevor Case. His ex had called police after the two had an argument, worried that Case might harm himself. And when his ex-girlfriend told Case that she was going to call the police, he threatened to harm anyone who came to his home, clearly not wanting the government to break and enter. Even so, local police officers arrived, knocked, walked around, shined their lights through the windows for about 40 minutes before entering without a warrant and shooting Trevor Case. What about our Fourth Amendment right to be free from warrantless entry?
Thank you, Mr. Chief Justice, and may it please the court. This court has never allowed state officials to force their way into someone's home without a warrant or probable cause. It should not start now. There is no liberty interest more deeply rooted in the Fourth Amendment than the sanctity of the home. The court has long recognized that physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. And the facts here well illustrate what's at stake with such entries. The police entered Trevor Case's home without permission, a warrant, or even probable cause, and they ended up shooting him in his own house.
A recent Harvard Law Review study found that 93% of warrants are approved on first submission, and that the median time it takes for a judge to review them is only 3 minutes. In fact, 1 out of every 10 warrants is approved in less than 1 minute. And with modern technology, obtaining a warrant is as easy as filling out the blanks on a warrant template and submitting it to a judge from an app on a police officer's phone. So, why didn't Montana police get a warrant before violating Trevor Case's rights? Does the DOJ think this is okay? We don't have the body cam footage to show you, but we do have the transcripts giving us a detailed record of what really happened during those 40 minutes. One police officer said, "We've got a pretty decent look into most of these rooms." "I don't see anything," said another. The officers noticed an empty handgun holster and a notepad with handwriting, which the officers took potentially to be a suicide note. They also saw empty beer cans. The officers announced themselves, knocked on the door, shined flashlights, and yelled through open windows. And this is where it gets really interesting. The officers got nervous standing around a gun owner's yard like that, so they went back to their patrol cars, grabbed rifles and a ballistic shield. Standing around armed and weighing whether to kick in Case's door with rifles and shields without a warrant, the officers in this small town discussed their legal right to enter and what they knew about the gun owner. One officer remarked that Case likes to drink and just go off somewhere and wait for everybody to cry for him, noting that this is probably about the 10th time I've dealt with him doing this. Referring to the likelihood that Case had already shot himself and needed medical attention, transcripts show another officer asked if they should stage medical because if he's got a self-inflicted gunshot wound. So the officer was worried about the health and safety of the gun owner and didn't want to stage medical outside in case he got shot during a warrantless home invasion. Next, that same officer also noted that the chances are pretty slim that Trevor Case actually urgently needed medical attention. So basically, all the officers on the scene stated that it was unlikely Case required immediate aid, but rather was just hiding in his own house, waiting to see if they would kick in the door. Officers also thought about calling Case's ex-wife, his father, or even calling Case on the phone to see if he was okay. In the end, they didn't call anyone and instead decided that kicking down his door without a warrant was the best course of action. The state of Montana actually called the police's tactic a protective sweep. After all, the police argued it was an emergency. So that's why they stood outside for almost an hour before kicking in the door. Obviously startled and upset at the home intrusion without a warrant, Case allegedly gritted his teeth at police, had an aggressive look on his face, and they claimed they saw a gun. Claiming self-defense, the cop shot Case in his abdomen and arm, but thankfully he ended up surviving. A gun was recovered near Case in a laundry hamper. Now in the Supreme Court's 2021 ruling in Coniglia v. Strom, a case in which GOA submitted an amicus and gun owners won, the court unanimously said that there's no community caretaking exception for the Fourth Amendment for homes. In Coniglia, cops entered a man's home without a warrant and seized his guns, claiming they weren't acting in a law enforcement capacity, but instead as community caretakers. Justice Thomas shut that argument down. If you're not acting as law enforcement, then you're no better than any common criminal who breaks and enters. The Fourth Amendment protects the home from unreasonable intrusions. The court left open the possibility that the police could enter a home if there are so-called exigent circumstances, such as imminent injury or death. But they rejected the notion that there's some freestanding exception for police to enter your home without a warrant, just to help out as so-called caretakers. So fast forward to Case v. Montana. The Montana Supreme Court upheld the cop's actions, saying reasonable suspicion that Case might need aid was enough to break down his door. No warrant required. That's a dangerous loophole. Reasonable suspicion is a low standard, much lower than probable cause. It lets cops bust into homes on a hunch, turning welfare checks into SWAT raids with guns pointed. As GOA's prior brief hammered home, the Montana Supreme Court erred in attempting to craft a path around the court's unanimous decision in Coniglia v. Strom, issued just 4 years ago. We pointed out how the Montana court misread Coniglia to authorize some sweeping emergency exception, not to mention how Montana ignored private property rights principles from cases like United States v. Jones and Florida v. Jardines, wrongly interest balancing reasonableness over the Fourth Amendment's text. GOA's brief also tied this Fourth Amendment infringement to the Second Amendment. The way that this court rejected interest balancing in Heller should be instructive to the Fourth Amendment. Because if courts can balance away your Fourth Amendment right to be secure in your home, the place where you keep your guns, what's next for the Second Amendment? Armed police officers breaking down your door is especially problematic where there's a law-abiding gun owner on the other end. And we've seen the results time and again, like the death of Brian Malinowski in Arkansas or John Quinn in Quinn v. Texas, where the police conducted a no-knock warrant solely on the basis that Quinn was a gun owner. Of course, it's one thing if a state like Montana makes arguments to undermine the Fourth Amendment. But here's the kicker. The DOJ jumped in with an amicus brief of its own supporting Montana, breaking the reasonable suspicion standard for warrantless entries in so-called emergency aid situations like cases. DOJ is arguing that when cops aren't engaged in law enforcement functions like hunting for evidence or catching bad guys, but rather are merely providing aid, probable cause and a warrant aren't needed. But this sort of claim is straight out of the anti-gun playbook. In fact, DOJ finds itself on the same side of the Michigan-led coalition of 35 states, mostly leftist ones, that are pushing the Supreme Court to allow invasive police actions without warrants. Now, you would think that if the DOJ found itself on the same side as Michigan Governor Gretchen Whitmer, maybe somebody would see a problem, but apparently not. As GOA's brief warns, the decision of the court below granted discretion to police to expand the powers of police and diminish the protection of the people under the Fourth Amendment. This undermines the home's sanctity and could lead to more abuses against gun owners. Just think about it. A neighbor could call in a welfare check because they heard you and your spouse arguing, and then the cops could kick in your door claiming they're merely providing aid. Maybe you get shot, maybe you get killed, maybe a completely innocent person gets harmed. And based off the Montana court's reasoning, because the police had your best interests at heart, that's all that matters. They were just caretakers after all. And that's why they kick down your door with their guns drawn. This is the sort of logic that appeals only to government lawyers. And the fact that the DOJ is defending this, it's a Fourth Amendment nightmare. This reasoning from the DOJ isn't isolated. It's part of a serious pattern of growing pains we've had with the DOJ when it comes to protecting our constitutional rights. Take the DOJ's First Amendment gag order that has kept GOA from printing the news. For nearly 2 years, GOA and our lawyers have been under a court-imposed gag order stopping us from reporting on a Freedom of Information Act request we filed exposing the ATF secret NICS surveillance program. Under this program, ATF spies on legal gun buys without warrants, flagging suspicious patterns, and then makes a record of all the guns their targeted individual purchases. In other words, a pure Second Amendment and Fourth Amendment violation. In our FOIA case, ATF accidentally sent us some unredacted documents. But even though they were the negligent ones, DOJ ran to court and demanded a protective order. And the court obliged. We can't disseminate or use the documents ATF gave us, says the judge. We thought that maybe this was just one or two rogue DOJ attorneys, holdovers from the Biden administration acting on their own. But now that we've appealed the case to the Court of Appeals, we had hoped DOJ would come to its senses and abandon Biden's First Amendment violation, but we were wrong. The current DOJ is picking up where Biden's lawyers left off and continuing to argue that there's no First Amendment infringement in gagging a gun rights group from publishing news, a classic prior restraint that the Supreme Court virtually never allows. As D.C. District Judge Moss said in a similar case, ordering journalists to return lawfully obtained information would be extraordinary. But DOJ apparently doesn't see the problem and is fighting to keep us silent. Opposing First Amendment speech? Check. Similarly, we saw the DOJ continue the Biden administration's arguments against zero tolerance. Earlier this year, FBI Director Kash Patel ended the enforcement of the Biden-era zero tolerance policy, which is great. But then DOJ tried to moot our cases, which would prevent us from getting a lasting judgment that the policy was unlawful, despite years of legal efforts and thousands of dollars in attorneys and court fees paid by our members. But then after arguing that our case is moot, the DOJ told us the government has no plans to abandon its previous arguments. That's what they told us in an email. The DOJ is picking up right where Biden left off. But the problem is that the Biden administration had argued that zero tolerance didn't violate the Second Amendment. As DOJ claimed, there is no Second Amendment right of a private business to sell a firearm. And so to sum all of this up, the DOJ thinks it's perfectly permissible to gag the press, stopping GOA from printing the news about unlawful and unconstitutional government surveillance of gun owners. Second, DOJ says that there's no Second Amendment right for a business to sell a firearm. And third, the DOJ believes that without a warrant, the police can bust down your door if they're there to aid you. This cannot possibly be the sort of constitutional restoration that President Trump had in mind. He's already done so much good on this issue. This sort of DOJ malfeasance is not why tens of millions of gun owners came out to vote in November. But for gun owners and other Americans that care about these issues, this is very fixable. President Trump created a Second Amendment task force, so let's make that work. Call the White House at 202-456-1111 and tell them, align DOJ and ATF with President Trump's agenda. Drop anti-gun arguments, lift the gag order, and oppose warrantless police entries into gun owners' homes. Your pressure has won before, like dropping the Taranto pistol brace charge, the DOJ ending Biden's support of Letitia James's crusade against Brownells. DOJ can be pressured to do the right thing again. And so thanks for watching. Like, comment, and subscribe. Share this video, most importantly, to spread the word. Stay vigilant, and remember, no compromises.